And there's a law that the district attorney knew about, her investigator knew about. Everybody knew that this had happened to me. And the law states you do not jail somebody if because what happened to them leads to other things that can put them in jail. Literally, that's what the law says. But she failed to let the judge know that. And if he knew that, he didn't care. And that matters. It matters. I'm just gonna delete all the hateful comments. All right. Okay, so I've never read this before, and I'm going to read it, and hopefully it'll give you a little bit of understanding. I know that Cecilia was live last night talking about my story. Now, this is the thing. There's some people, I want to make it really clear. Robin Coates says, I've been a follower of yours for quite some time. I don't comment much, but I want you to know I feel so horrible for what has happened to you in your life. Your girls should have never had to know what it was like to lose their mom in such a horrible, untruthful situation. You're beautiful. Thank you so much. Thank you. She's under, all of this is happening because she's under scrutiny right now, because she has given conflicting statements to the public about the months leading up. Her and a man named John Allen were trying to pay people to do bad things to me. To get me drunk, to get me high on drugs, to have drugs put in my car. And she has made too many conflicting statements. And she's gotten to the point where she is completely discredited. And because she's doing this right after her and her sister stated that they were going to start making money off me, so they stuck up for me. And they said, well, if you do that, then we're going to start talking about how your sister has her own issues that she doesn't want people talking about, that are much more serious than anything that you can say about Vanessa. What's good for the goose is good for the gander. Oh, yeah, I used to say that. Yeah, I did. For all those people that have been making comments like, spectators. You are merely spectators, but it is that kind of hate with misinformation that gets into the minds of these people that think they can harm somebody by either promoting the same false information or by putting hands on them. I have every single time that I went to the FBI. I had every single time, and all they did was call the first district attorney who I had, voted out. And all he said was, oh no, she's been arrested for this and this. That's why they needed me to be arrested. They needed me to have mugshots. Because they couldn't figure out another way to get people to not, they were like, if we have a mugshot, people won't listen to her. Until they did it too much. Until it became an incredibly outrageous number of times. And what I don't understand is these other people that have an opinion, also, the ones that have made a name for themselves, they're like, well, Vanessa should have done this and that. You don't know what Vanessa should have done unless you're Vanessa. The personal decisions of another human being have shit to do with your life. Which means your opinion out of any of the 7 billion on the planet matters the least. And I basically have stayed quiet. But Ofelia Moreno is going too far. She's going too far. So while she's out there, stating things like she stated last night, are we forgetting what our job was? Are we forgetting? Because Manny didn't forget. AKA Manny still is going after Vanessa. I didn't forget. AKA I'm still going after Vanessa. That hate page didn't forget. They're still going after Vanessa. Yeah, you three are the only ones, because you all are the worst. Do you not get it? Do you not get it? I'm not surprised if you don't. I'm not surprised if you don't. I've always stated for the public to please The entire fucking campus followed me down a hall to the principal's office. If you didn't know about who I was, that's not my fault. But that same fighting, ungiving up, unflinching spirit, that same no fucks, I don't care how big you are, I don't care how many family members you have, I don't care, is still in me. Simply because I became a nurse and I suppressed it doesn't mean that it wasn't there. That sleeping dragon was always there. She was dormant. She didn't need to come out. But you wanted to deny justice to her children, and you wanted to ruin her life. So she needed to show you who the fuck she was. And show you I did. The thing is, Ofelia Moreno doesn't have that legacy. Also, before my arrests, before this, I didn't have a history of violence. I'd been a nurse since 18. You can't have a history of violence. She did. She has a history of violence. She has a history of breaking the bones of the face of a woman in Washington and bragging about it. And she's been like that her entire life. I didn't demonstrate a life like that. Throughout elementary school, throughout junior high, throughout high school, I did demonstrate a rebellious quality simply because I wasn't going to put up with the riffraff trying to harm me. That was it. That's all. I never ever had the reputation of wanting to terrorize humans and beat their faces, being violent. I was never in trouble in school for being violent. I get in trouble for fighting back, but never initiating anything. Y'all don't listen to people like Rhonda, okay? Now keep in mind, regardless of what Ofelia Moreno's sister says, Ofelia Moreno's sister has no idea of the existence of what we know and what the district attorney knows. She's going to have to answer to her state bar and say, why did you not prosecute those officers? And why did you not stop the prosecution against that defendant? Watch. 3. The pretrial hearing date for this case has consistently moved on the docket. For the last 4 years, this is expected, so as to make certain this case is not addressed until the pending felony case in the 197th District Court 2023-CR-0025A, which also arose from the same events that took place on June 3rd of 2020, which has been disposed of. Without notice to defendant or her lawyer, number 4, either by announcement made in open court by personal service upon the defendant or her attorney, or by mail to the defendant or her attorney, and not in accordance with the Texas Code of Criminal Procedure, Chapter 28, Article 28.01, Section 2, this case was placed on the docket for the date of March 19, 2024. The state was aware that both defendant and her attorney were expected to be in a jury trial in the 197 District Court in Cameron County starting March 18th, 2024. The day before. The day before. Background. On or about October 2014, defendant's 2 sons were at the time 11 years old and 16 years old. Both sons were suffering several Class A assaults during the course of the school day at Raymondville Independent School District. The older son was being assaulted by a disgruntled ex-girlfriend between classes. This was caught on surveillance cameras. The younger son was being assaulted by several different children in 1 month alone, amounting to 12 Class A assaults in the span of 30 days. As defendant commenced with doing her due diligence as a parent and as a mandated reporter, defendant was being stonewalled with every attempt to protect her sons. Ultimately, in November of 2014, defendant and the younger son outed the school district for their failure to protect him in a post that went viral worldwide, surpassing 7 million views in less than 3 days. As is reasonable to imagine, in a small community, this did not sit well with the superintendent of Raymondville Independent School District, or with the school police, who were denying defendants' right to pursue charges with any assault greater than a Class C assault. Those events also increased the difficulty for defendant to be able to defend her older son. The parents, family, and friends of those damaging her sons, as well as the family and friends of the officials who were neglecting the defendant's legitimate complaints. An entire community was upset to the point of demonstrating hate in every way imaginable towards the defendant. All this merely because a mother was doing the most any parent could possibly do in her situation, seeking justice by implementing democracy for her sons, for herself, and for her family. 7. Events occurred in the beginning of May 2014, which led to the arrest of the older son's aggressor for assaulting defendant, the mother of the older son, in view of an officer. Days later, the defendant was finally able to successfully petition and was granted a protective order protecting her son and herself from her son's aggressor. Defendant had to be physically hurt before the right thing was done. And it's true, because I asked for this protection before I was assaulted. 8. The mother of the aggressor then sought revenge by way of damaging the defendant by weaponizing law enforcement against defendant. Specifically, the City of Raymondville Municipal Court, a detective from the City of Raymondville Police Department, and several patrol officers from the City of Raymondville Police Department. The Raymondville Municipal Court. Armin Martinez, raised in Raymondville, and the uncle of defendant's aggressor. This individual got his start as a law enforcement officer in the same City of Raymondville Police Department. This individual was the previous Raymondville Municipal Court judge. After losing his re-election, he went on to become the Lyford Municipal Court judge, while at the same time he was employed as a police officer at the City of Raymondville Police Department. After several complaints submitted from multiple lawyers of defendants in his court to the State Commission on Judicial Conduct, This individual entered an agreement to resign from the bench and to never seek an elected seat again in lieu of disciplinary action by the commission. Exhibit A. Yes, I provided exhibits. The City of Raymondville detective. I'm not going to say his name. I'm not going to say his name. Okay? That's how nice I'm going to be. All right? And I hope you notice that. So-and-so officer detective, also raised in Raymondville, this individual got his start as a law enforcement officer in the same City of Raymondville Police Department. He is the detective's, a certain other person is this detective's relative, also from Raymondville. Also got his start as law enforcement officer at the same City of Raymondville Police Department. That person is a former DPS trooper who suspiciously left the DPS at a young age voluntarily. In recent years, he has been arrested while working as a law enforcement officer at the Lower Rio Grande Valley Development Council Regional Police Academy, Exhibit B. The arrest occurred after several cadets filed complaints alleging abuses of power and official oppression. This name I will say. Juan Maldonado. This detective's uncle and the brother of the above-named arrested officer also got his start as a law enforcement officer in the same City of Raymondville Police Department. Sergeant Juan Maldonado is the first state police officer fired by the DPS in the aftermath of a botched police response to the worst school shooting in Texas history. Sergeant Juan Maldonado was the highest-ranking state trooper to initially respond to Robb Elementary, and one of the 19 officers who stood in the hallway of Robb Elementary did nothing to attempt to neutralize the shooter or implement post-Columbine active shooter protocol, while 21 lives and 2 classrooms of children with their teachers begged the police who they heard in the hallway to save them. Instead, Juan Maldonado was one of 19 officers who allowed 21 lives to be gunned down like fish in a barrel. And I added the link and the Exhibit C. City of Raymondville law enforcement officers. Body camera footage of that day depicts officers with absolute impunity, no fear of consequence. Taking orders from the mother of defendant's aggressor, only one reasonable officer voiced his concerns, thank you, sir, about not following her orders. Should this motion be set for hearing, this footage will be added and marked as exhibits accordingly. What no other reasonable detective would have done as a detective of the City of Raymondville Police Department, this officer did. This detective did. He did this by allowing the mother of the defendant's aggressor to file a frivolous complaint, stating that at the same time her daughter assaulted the defendant, the defendant had hit her. The aggressor's mother understood that anything she asked for, corrupt or not, would come to fruition. They would do it, including conspiring with law enforcement to orchestrate the humiliation of the victim by being arrested the way that her daughter was arrested, violating the constitutional rights of the defendant. The detective was more than willing to oblige, and oblige he did. The aforementioned details are important in laying the foundation for this motion, as the common knowledge that a culture of corruption in the City of Raymondville Municipal Court and the City of Raymondville Police Department has existed and does currently exist. Not only does it cast a negative light on the judiciary in every court of Texas, most importantly, for the citizens of Raymondville, an arrest could lead to one's entire life being destroyed, knowingly, in bad faith, with malice, and with impunity, which is what was done to the life of the defendant, me. 10. First arrest. Defendant arrested May 30th, 2014. Date of disposition, March 21st, 2016. Outcome, not guilty. Cause number 14-08118, aka docket number 1469-69180, assault by contact. The Raymondville Municipal Court Judge Armin Martinez had his clerk sign the warrant, and it was disposed of on March 21st, 2016. On Friday, May 30th, 2014, 2 weeks after defendant and her son were granted the protective order protecting her son and herself from the aggressor, of both the defendant and her older son, and as defendant was peacefully in her home, there was a knock on her door. Standing there was the same City of Raymondville police officer previously depicted on video footage taking orders from the defendant's aggessor's mother, demanding that defendant step out of her home. As soon as the defendant stepped out of her home, she was immediately handcuffed. Although the warrant was in his hand, this officer did not care that the warrant shall, because the law says shall, hand it over to me if I ask you to see it. It doesn't say may, it says shall. He didn't care. By the way, all of the officers that I mentioned here right now are no longer working at any law enforcement agency that I know of. That matters. Because at the time that this was happening, the whole town was against me. They're not going to feel bad. But I want the public to see that the whole town was against me when eventually circumstances would occur. None of these officers are working anywhere. I doubt even the DPS trooper from Uvalde is working anywhere. She was immediately handcuffed. Although the warrant was in his hand, the officer did not care that the warrant shall be shown to the individual arrested. He refused to do so even as the defendant begged and pleaded to see the warrant. While in custody, the defendant was publicly humiliated by being taken in handcuffs down her driveway to the patrol car. The defendant's aggressor was seen passing by. The mother and daughter, coincidentally, were passing by at that very moment, as if it wasn't orchestrated, right? And recording. The mother was driving and the girl was in the backseat on her knees recording my arrest. While hiding in the backseat of her mother's vehicle due to the protective order, they actually had a protective order prohibiting them driving past my house, even though it is a major highway. Yeah, they weren't supposed to be doing that. The officer, did he care? No, he didn't. No. I requested the body camera footage and the footage from the police car itself. And you can hear me telling him, and he wasn't caring. The defendant stated her concerns about leaving her 16-year-old son. So when they did this to me, they left my 16-year-old son alone to care for his 11-year-old brother, his 2-year-old sister, and 9-month-old sister. I'm not kidding. I'm not kidding. I'm not kidding. They didn't care. They didn't care. As the children had never been left without the care of an adult before, none of this was a matter of importance to this officer. Body camera footage obtained from the arresting officer's body camera that day proves this. Should this motion be set for hearing? Because this motion, by the way, the judge can get this motion and agree to recuse herself, or she could fight it. And that at that point when she chose to fight it, that's when it would be set for hearing. So when you hear me say, should this motion be set for hearing, is when I will add the footage as exhibits. Should this motion be set for hearing, this footage will be added. On March 29, 2016, the same individual involved in defendant's first arrest, the older son's aggressor, who also assaulted defendant in view of an officer, who was subsequently arrested, and along the mother, one of the aggressors of the defendant's younger sons, one of the multiple students who assaulted defendant's younger son. So, the mother of the aggressor, the mother of the girl who had the detectives arrest me, and one of the mothers of my younger son's bully, right? They went to a justice of the peace. They went to Judge Solis, a justice of the peace. These two individuals demanded that Justice Solis do something so that the defendant would no longer mention their names on social media. By this time, with validation of the verdict from the first unconstitutional arrest, the affirming words of District Court Judge Alex W. Gabbert, defendant had been, by way of democracy, speaking of the injustice that after that first case and after what he said, I never shut up about it. I never shut up about it because that proved from that moment all of their intentions. That's why I never shut up about it. Speaking of the injustice that occurred to her family and how defendant was not going to give up seeking justice, I kept talking about it. These ladies did not want me talking about it. Defendant's lawyer warned. I took a lawyer with me to Justice of the Peace Court. Hardly anybody does. I did. Defendant's lawyer warned Judge Solis that doing such a thing would be a violation of the defendant's constitutional rights. As is common practice in Willacy County, with complete impunity, no fear of consequence, Judge Solis placed a peace bond on the defendant, which stated that if defendant were to mention the names of either women, defendant would have to pay a substantial fine, face jail time, and or both. The official oppression and abuses of power of former District Attorney Bernard Ammerman. This was the first District Attorney. The one that everybody said was impossible to be, this was one of the worst ones. On May of 2016, the defendant was arrested after leaving a Willacy County Commissioner's meeting. I have been arrested after every time I demonstrated a constitutionally protected right. That matters. In the eyes of the United States Department of Justice, that very much matters. In May of 2016, the defendant was arrested after leaving a Willacy County Commissioner's meeting in which defendant voiced concerns to the Willacy County Commissioners regarding the importance of taking caution with Bernard Ammerman, as it was common knowledge in Willacy County and well known for him to abuse his powers in retaliation against citizens who implemented democracy to speak against the corruption of the Willacy County District Attorney's Office. This was 2 weeks after the defendant launched a negative campaign against District Attorney Bernard Ammerman and when he lost his elected seat. This was 2 weeks after he realized that he lost the election. His defeat was fresh, and he knew the defendant wielded those votes. He knew that it was because of me, the very votes that ultimately caused him to lose his elected seat. This display is included in the following videos. All of that was recorded, that whole meeting. This video can be found on the following YouTube channel. The link is there. The title of this video is called Bernard Ammerman, Corrupt Prosecutor. Should this motion be set for hearing, this footage will be added and marked as exhibits accordingly. In 2014, when defendant was begging and pleading with this district attorney to help her sons with the refusal of the school and the city officers to allow the defendant to pursue charges against those assaulting her younger son, and when she then went back many times after her first unconstitutional arrest to make a complaint to Bernard Ammerman of official misconduct, to report those officers to him because that's his job. Bernard Ammerman had instructed his staff, he did, to ignore defendant and not acknowledge her. How do y'all, the former staff of Bernard Ammerman, how do y'all feel about how you all listen to him to ignore me? Y'all will forever be known as those people. I forgive you, but you all will forever be known as the staff that listened to that prosecutor. It doesn't matter if he's your boss. You don't do corrupt shit. He instructed his staff to ignore the defendant and not even acknowledge her, at which point the defendant submitted a grievance to the state bar. I did. The defendant, naively assuming that this attempt to grieve against him would somehow urge Bernard Ammerman to do the right thing, defendant then returned to Bernard Ammerman again to file a complaint again of official misconduct against all of the officers that had damaged her life. By this time, there was proof, even after everything that Judge Gabbert said already existed. So why are you not going after these officers when the judge openly stated they committed official misconduct? Instead of doing what he took an oath to do as a prosecutor, he chose to retaliate against the defendant and continue the same pattern and practice of treating defendant as a nuisance and an adversary instead of what the defendant actually was, which was a legitimate complainant. This encounter is depicted in the following video, and I have the link there. This video can be found on the following YouTube channel. The title of this video is Corrupt Texas DA Bernard Ammerman Lying and Retaliating. Should this motion be set for hearing, this footage will be added and marked as exhibits accordingly. In the aforementioned video, Bernard Ammerman is answering forever when defendant asked him, how long are the services of the district attorney's office not going to be available to me and my family? He goes on to state, I am not Walmart. I don't take complaints. I'm not kidding. He said that. He said that. The link is on my YouTube. He is seen denying that one of his duties, because he goes on to say that he's denying that one of his duties was to take complaints on official misconduct. A district attorney only has 3 duties in Texas: take complaints on official misconduct, seek justice, and some weird thing with child support. Bernard Ammerman, in his own voice, notifies the defendant that the only way things would change is for him to be voted out of his elected seat. The defendant took Bernard Ammerman's words as a challenge, holding on to the video of that encounter from 2014 until his re-election in 2016. The official oppression and abuses of power of former Willacy County Assistant District Attorney Charles E. Mattingly Jr. If you're his family members and friends, if you're mad because he has been deceased, that's not my fault. This is part of my story. He did this to me. Not my fault. Not my fault. By the time 2016 came around and defendant was speaking at the Willacy County Commissioners meeting, as is pattern and practice of malicious prosecution, official oppression, and abuse of power, Bernard Ammerman had been holding on to an active arrest warrant for violating the peace bond that was previously placed on the defendant by the Justice of the Peace. The unconstitutional move and the same pattern of practice of malicious prosecution, official oppression, and abuse of power displayed by Judge Solis, then Justice of the Peace of Willacy County. Since that day in Judge Solis's courtroom, the defendant continued to exert her constitutional right of freedom of speech to mention the names of those that harmed her and all the school, city, and county officials that helped and enabled those who harmed her. Why would Bernard Ammerman hold on to this warrant when he could have had the warrant executed sooner? Before the defendant spoke at the Willacy County Commissioners meeting, he had it as an ace in his pocket. By this time, Bernard Ammerman understood that defendant utilized democracy in the loudest, strongest, and most meaningful ways possible. Bernard Ammerman knew that he had less than 1 year before the new district attorney was sworn in, and during that time, the defendant was going to be unrelenting. Bernard Ammerman held on to that warrant to be able to execute it at an opportune time, especially at a time when a mugshot is needed to try to discredit the defendant in the eyes of the public if she continued to be successful in gaining attention while seeking justice. At the end of that meeting, Assistant District Attorney Charles Chuck Mattingly Jr. is seen acknowledging Bernard Ammerman's order. You can see Bernard Ammerman tell him, in my video, you can see Bernard Ammerman give him the, do it. And they already had that plan for that, for when that moment happened. Is seen acknowledging Bernard Ammerman's order to have the warrant executed. 10 minutes later, after leaving that meeting, the defendant was arrested. Guess who the arresting officer was? The arresting officer was the same individual who was the corrupt City of Raymondville Municipal Court judge, Armin Martinez. No longer the municipal court judge due to the efforts of the person, the defendant, that he was about to place in handcuffs. When his partner was handcuffing the defendant's hands in front of her body, Officer Martinez insisted that the defendant be handcuffed with her arms behind her body, just to be mean. You could see that in his officer body camera footage. Any little bit of discomfort that Officer Martinez could cause for defendant, he was going to cause, continuing the same pattern and practices he demonstrated in his position as a judge. This case was never formally disposed of, nor was there ever a court date, most likely because they discovered they could not maliciously prosecute the defendant in this case, because it was done unconstitutionally, the peace bond. What reason would these officials have to suddenly not go forward with this prosecution? It was likely because the defendant had successfully grieved to the State Commission on Judicial Conduct, whereupon Judge Solis received private sanction as follows. You can read this on the Judicial Commission website. Private warning and order of additional education of Justice of the Peace, March 29, 2016. Quote, this is from the Judicial Commission. The judge failed to comply with the law and demonstrated a lack of professional competence in the law to the extent that the judge used the peace bond process to improperly enjoin a litigant from exercising her rights to free speech under the United States Constitution. That is a violation of Canons 2A and 3B2 of the Texas Code of Judicial Conduct, Exhibit D. This fact demonstrates that the judge of this court, the motion this judge addresses, Judge Felicita Gutierrez, was also unable to identify whether she was signing an unconstitutional warrant, because she signed the warrant. That's one of the reasons that I was writing this. How is this judge, who could not identify that she should not be signing a warrant that's unconstitutional, going to rule against one of my other cases? I don't think so. I don't think so. This fact demonstrates that this judge of this court, the motion this judge addresses, Judge Felicita Gutierrez, was also unable to identify whether she was signing an unconstitutional warrant or she signed it knowingly and with no fear of consequence, both of which resulted in damage and undue burden to the defendant. Most importantly, the judge's participation cast a dark light on the judiciary. 14. Defendant arrested November 5th, 2016. Date of disposition, March 18, 2024. Outcome dismissed by judge. Cause number 2016-CR-00798, theft, food stamp fraud. Warrant signed by Judge Felicita Gutierrez, first dismissed January 10th, 2019 by District Attorney Annette Hinojosa, re-indicted, coincidentally, during my election against Senator, what's his name? Lucio. First dismissed January 10, 2019 by District Attorney Annette Hinojosa, re-indicted August 27, 2020. This is when Annette Hinojosa re-indicted it. But while she was doing all this, instead of re-indicting Amanda, I went on to be Amanda's third victim. Instead of re-indicting Amanda on attempted murder, she failed to indict her and instead put effort into indicting me for that, a non-violent crime. I'm not kidding. I'm not kidding. I wonder how she's going to explain that to the State Bar. As cause number 202-2020-CR-00908, theft, food stamp, and Medicaid fraud. After change of venue to Cameron County, the cause number was changed to 2021 DCR-2357. In October of 2016, during the defendant's first election for U.S. Congress and 6 months after losing his re-election for district attorney, Bernard Ammerman continued his pattern of practice of malicious prosecution, retaliative prosecution, official oppression, and abuse of power. He convened a grand jury to indict the defendant. The witnesses he used included the same individuals involved in the defendant's prior unconstitutional arrest. The mother of the defendant's aggressor and the mother of the bully of her younger son, the two women George Solis helped place a non-constitutional peace bond against defendant. These ladies gave false testimony about having personal knowledge of the defendant lying to the grand jury. And Annette Hinojosa allowed this. I'm sorry, Bernard Ammerman allowed this. And Annette Hinojosa allowed it knowing that you should never have allowed those people. You should never have gone forward with a case that allowed those two people. Ever. Bernard Ammerman knew that no witnesses existed to give testimony about the defendant. That's true. Because he knew when he maliciously commenced his prosecution, he was deliberately and recklessly crossing the line between legitimate adversarial gamesmanship and using improper methods to get the outcome he wanted from the grand jury, which included keeping from the grand jury that these witnesses not only had no personal knowledge of the defendant's life, and that they had previously both damaged defendant and both of defendant's sons. He was able to get a true bill from the grand jury, and like he did with the previous arrest, he held on to the arrest for the most opportune time, so that he could orchestrate the execution of the arrest on the first Saturday of early voting of the defendant's election for United States Congress. I was out within an hour. Why would Bernard Ammerman do this? He did it to retaliate against the defendant for the 9 months earlier that defendant protested him on a public sidewalk, on public property by his political tent during re-election, which was the same footage the defendant used in her campaign opposing his re-election. The defendant's mugshot was sent to any and all mainstream media, Channel 4, Channel 5, News 23 here in the Valley, in an attempt to shame and humiliate defendant, and it cast a negative light on defendant in the eyes of the public. The official oppression and abuses of power of District Attorney Annette Hinojosa. After years of the prosecution delaying this case, Annette Hinojosa, who was handed the baton of corruption from Bernard Ammerman, dismissed the case on January the 10th, 2019, only because no witnesses wanted to appear to defend their false allegations to the grand jury and risk arrest by perjury themselves in a trial. When the events of June 3rd, 2020 occurred, during another defendant's elections, Annette Hinojosa saw this as an opportunity to work with the father of defendant's daughters, and an exchange was made. The father exchanged his help in providing false, new information to get the defendant re-indicted, and District Attorney Annette Hinojosa helped him to avoid paying child support, as the state helped him in obtaining a protective order separating defendant from her daughters in the hopes the defendant would finally give up seeking justice and stop speaking of how all these officials abused their powers against her, participated in official oppression, in abuses of power, and malicious prosecutions, essentially destroying defendant's life. There is another deep-seated evil reason that Annette Hinojosa had for doing this, which will not be spoken of here, but it was to protect other wrongdoers from prosecution. That's what happened the next day after they separated me from my daughters. That's what I don't speak of. But what she did was also to protect other wrongdoers from prosecution. When a proper investigative agency is doing what they must do, this will be revealed at that time, because it's all documented. The official oppression and abuses of power of District Court Judge Adolfo Cordova. The protective order hearing that was orchestrated by Annette Hinojosa in exchange for the help of the father of the daughters of the defendant to get defendant re-indicted was presided by Judge Adolfo Cordova. The entire hearing was based on the events of June 3rd, 2020. The star witness was Raymondville police officer Stefan Ramirez. His testimony was allowed during a hearing which was largely based on his false allegations. Judge Cordova made his ruling callously and brutally separating two young daughters from their mother via protective order cause number 2020-CV-2 0212A. Ever since that day, defendant has not been able to speak or write to her two daughters, whom she raised alone prior to these officials conspiring to orchestrate the separation. No visitation, no phone calls, no pictures, nothing. Judge Cordova, with surgical precision and without fear of consequence, abused his power to excise a mother from the life of her daughters. During this very protective order hearing, Annette Hinojosa and her ADA became aware of not only exculpatory evidence, but also, and most critical, impeachment evidence that would have impeached the officer's testimony and proven that defendant could not have possibly been guilty of anything she was charged with that day. Judge Cordova abused his powers with complete impunity, knowingly suppressing important exculpatory evidence and impeachment evidence. The same evidence that is pertinent to the case before this court right now. With the help of Judge Cordova's participation, the father of the defendant's daughters received the outcome he needed to avoid paying child support, and District Attorney Annette Hinojosa, 1 month later, with the help of the father's false statements, re-indicted defendant on the previously dismissed 2016-CR-0079A, and by convincing the grand jury to issue a true bill, resulting in the re-indictment and newly named cause number 2020-CR-0090A, which led to the defendant's next arrest. The second arrest that election year, on August 27, 2020, defendant's mugshot was again sent to all mainstream media for the purposes of humiliating and shaming defendant and casting a negative light on the defendant in the eyes of the public. The official oppression and abuses of power of Senior District Court Judge J. Manuel Banales. No one talks about him, right? I'm going to talk about him because he did the same thing to me. Will he be grieved upon? Absolutely, also. He's going to have to answer to this. During a family law custody case, a hearing to recuse and disqualify Judge Cordova was made after Judge Cordova refused to recuse himself. Judge Cordova assigned Judge J. Manuel Banales, even as the defendant's lawyer at the time spelled out in detail every reason Judge Cordova should be recused, disqualified, including but not limited to making statements to the defendant in open court during her criminal cases. Just one example. Quote, respondent has had many unpleasant encounters with Judge Cordova as well. Significantly, in June 2020, Judge Cordova, sua sponte means on his own. Nobody told him to do it. He just did it on his own. Judge Cordova, sua sponte, ordered a psychological evaluation of respondent. Respondent underwent the psychological evaluation and was determined to be above average intelligence with no psychological impediments other than the attention deficit disorder that had been well treated. Recently, on or about November 19, 2020, Judge Cordova, in this court at a status hearing unrelated to that charge, again, sua sponte, on his own, ordered the respondent's bond revoked and committed her to jail. Respondent was not permitted to explain the circumstances before she was incarcerated. Respondent spent some 30 days in jail at a first trial of respondent's driving while intoxicated indictment in March of 2022. The judge brought a witness intimidating allegations against respondent before Judge Cordova. Judge Cordova gave a harsh admonishment, even though the charges of Knowing defendant had to protect herself, she finally agreed to the State Commission of Judicial Conduct on Judge Cordova for doing what he did. It was only then that she was finally able to get Judge Cordova away from presiding over any of her cases, both civil and criminal. However, by this time, irreparable damage had already been done by the hand of Judge Cordova directly and Judge Bañales indirectly with his enabling of Judge Cordova. In 2021, a change of venue to Cameron County changed the cause number 2021-DCR-2357 after years of delay. On March 18, 2024, the case was dismissed by a different presiding district court judge. Defendant arrested November 9th, 2017. Date listed by the Raymondville Municipal Court. But the arrest was actually December the 16th of 2017. It was the date listed by the Willacy County District Court. So they have two separate arrest dates. Date of disposition was September 28, 2023. The outcome was dismissed. Cause number was originally 2016-CV-001, violation of protective order stalking. The hate pages love to mention this. Here you go. District Attorney Annette Hinojosa by this time was officially oppressing me, abusing her powers against me, so she again had used bogus and trumped up charges and changed it to cause number 2017-CR-0046A. The warrant was again signed by Judge Felicita Gutierrez, dismissed, who this motion is for, dismissed September the 28th, 2023 by District Attorney Annette Hinojosa. After change of venue to Cameron County, the cause number was changed to 2021-DCR-2356. The official oppression and abuses of power of Assistant District Attorney Carlos Masso. Do I care that his family and friends and voters and supporters are going to have a problem with this? Absolutely fucking not. No. Are any of you helping me survive him? No. Did any of y'all help me survive him? No. No. Do I care if you talk shit about me on the internet? Absolutely not. This man was present during court for the case detailed in number 14 of this motion on March the 18th of 2024. Out of desperation by District Attorney Annette Hinojosa, who brought Carlos Masso, yeah, she did. She brought him. He doesn't even work for Willacy County. all were not there when I had to survive her. You all did not help me survive her. The only evidence offered at the protective order hearing, that one, was the 1-hour protest on the public sidewalk. That was their proof. I'm not kidding. I'm not kidding you. That was their only proof. They played it. That was their only proof. That's not how you get a protective order in Texas. But it is in corrupt Willacy County. This is evidence of that. Which was nothing more than the defendant demonstrating her constitutional right to protest and the most protected speech in the nation, political speech. The following is the video that was the only evidence offered by Carlos Mazo. The link is there. This video can be found on the following YouTube channel. The title of this video is Corrupt Texas DA Bernard Ammerman. He has done much worse to others. Should this motion be set for hearing, this footage will be added and marked as exhibits accordingly. As difficult as it is for true victims to petition for protective orders, any reasonable person would know that a video protesting a candidate is not enough to pass a protective order like candy. And if done, would be a serious violation of the constitutional rights of the person protesting. One would think there is no way these officials would attempt such a corrupt thing in open court, but it is Willacy County, South Texas, with no federal oversight. No federal oversight means operating with impunity, no fear of consequence. With the help of then District Court Judge Migdalia Lopez, a strong player in the corruption in Willacy County, and who 6 years prior had to, with her tail between her legs, return my oldest son back to me, back to defendant's custody after Judge Migdalia Lopez callously, she had already done this, and without merit took defendant's custody away and on court record stated, "You lost your son because you chose to work and go to school instead of staying home." I'm not even kidding. It's on court record. So I had already dealt with this corrupt official. You lost your son because you chose to work and go to school instead of staying home. Bernard Ammerman got his friend, District Court Judge Migdalia Lopez, to grant the protective order 2016-CV-001 to the mother of the defendant's aggressor. What would be District Attorney Bernard Ammerman's motive? As long as the protected individual in the protective order, the mother of the defendant's aggressor, was at the campaign tent with Bernard Ammerman, the defendant could not protest him on the public sidewalk due to the defendant now having to keep distance from the protected individual. In 2017, the defendant was falsely accused by this same human, the mother of the human who assaulted the defendant in view of the officer, of violating the same protective order that was unconstitutionally placed against me. So they used this unconstitutionally placed protective order. They still used it to get another violation. As is her pattern and practice of malicious prosecution, official oppression, prosecutorial misconduct, District Attorney Annette Hinojosa saw this as an opportunity to once more attempt to make the defendant a felon. Due to the additional false claims of stalking, District Attorney Annette Hinojosa saw this as an opportunity to trump up the charges. Thus, the cause number was changed to 2017-CR-00468 to reflect the increased level of infraction. What would be District Attorney Annette Hinojosa's motive? By trumping up the bogus charges and increasing the infraction, she increases the chances of a finding of guilty, and finally hitting her mark, making the defendant a felon, so that the defendant can finally be quiet about what these officials did to her life, and so the defendant will have no credibility in the eyes of the public for the rest of her life as a convicted felon, ensuring that the claims of injustice of all officials who abuse their powers against the defendant will never be believed. She did this again to save her friends from going down in history as some of the most corrupt individuals to hold political positions in South Texas. Defendant was arrested November the 9th, 2017. After a change of venue to Cameron County, the case was named 2021-DCR-2356. After years of delay by the district attorney, the case was dismissed on September the 28th of 2023. Most likely because Annette Hinojosa never expected that the defendant would ever demand jury trials for every allegation that led to an arrest. Instead of taking a plea deal, by demanding a jury trial, this forces witnesses to back up their false statements, and if they gave false testimony, that would lead to an arrest of an innocent that led to an arrest. Instead, if they give false testimony that led to an arrest of an innocent person, they risk committing perjury and being arrested themselves. 16. Defendant arrested June 11, 2019. Date of disposition, it's an open case. Cause number 2019-CC-0252, theft of property, warrant signed by Judge Felicita Gutierrez. This case is still open after 6 years, although it's not open anymore. It has been abated. On June the 10th, 2019, the defendant had just buried a very close friend and that night went to a local eatery in Raymondville. Defendant was accused of stealing sunglasses within hours, as is the pattern and practice of the City of Raymondville Police Department to target defendant by implementing a malicious prosecution when no other reasonable law enforcement officer would pursue such a case. A warrant was immediately signed. Likely the fastest warrant ever to be signed and executed in the history of all of the City of Raymondville. Defendant presented herself to the City of Raymondville Police Department to expedite the process of booking, knowing that she needed to get back to work soon. The eatery where the defendant was accused of allegedly committing this crime does not allow thievery of any kind and has been known to refuse service to some individuals. This eatery before that day and since that day has demonstrated the utmost hospitality to the defendant. To this day, warmly welcoming and receiving the defendant each time she has been a patron since the day of those false allegations. 17. Defendant arrested June 3rd, 2020. Date of disposition, open case, outcome, open case. Cause number 7391, paraphernalia. This is the case this motion pertains to. The City of Raymondville Municipal Court, open case, cause number CR-CCR-028, interference with public duties in the Willacy County Court, and open case, cause number 2020-CR-0091A, DWI with child passenger. The case went to trial twice and each time ended in a mistrial. After one mistrial, the jurors were polled and all jurors raised their hand to indicate that they would not have found defendant guilty of the charges. As is the pattern and practice of District Attorney Annette Hinojosa to seek a conviction rather than to seek justice, she dismissed the case. Out of fear of the defendant obtaining an acquittal and likely causing a case of double jeopardy, she did the following. To increase her hitting her aim, which has always been to make the defendant a felon, the same day she dismissed the case, she re-indicted the defendant by dismissing cause number 2020 to protect the officers she works with closely, no matter how badly they misconduct themselves, and no matter what citizen's life she destroys and damages, as long as her officers are protected and their reputations stay intact. That is all that matters to District Attorney Annette Hinojosa. 18. Public remarks made by Judge Felicita Gutierrez regarding this case, demonstrating prior knowledge of the case. Since defendant's arrest on June 3, 2020, several young adults, mostly females who have had cases before Judge Felicita Gutierrez, have confessed to the defendant that during their court cases and in view of others in open court, Judge Gutierrez has admonished them by stating different versions of, quote, "You saw what happened to Vanessa Tijerina. You know how they took her children for what she did. You don't want that to happen to you, do you?" Out of fear of retaliation, the affidavits of these females will not be attached to this motion at this time. Should this motion be set for hearing, these young ladies are willing to attend the trial and state their testimony so that it can be on record. Number 19, public comments made on social media against defendant by Judge Felicita Gutierrez. On Monday, March the 11th, 2019, defendant exerted her constitutional right of free speech and demonstrated democracy by creating a post on Facebook detailing the official misconduct of officers that had already been proven in a court of law by District Court Judge Gabbert, and her personal opinions and thoughts regarding District Attorney Annette Hinojosa. All those who abused their powers against the defendant and defendant's dislike for judges who sign unconstitutional orders and unconstitutional warrants. Judge Felicita Gutierrez commented on that post as follows, quotes, "I'd like to report all your videos as personal attacks on me and other people. You make false statements and do not allow anyone to disagree. You're a lot like Sarah Huckabee, LOL." And a laughing emoticon. Number 20, Judge Felicita Gutierrez has demonstrated bias towards the prosecution and created a situation that allowed the prosecution to make false statements to defendant's lawyer. On Tuesday, March the 19th, 2024, Judge Felicita Gutierrez allowed this case to be placed on the docket without notice to defendant or her lawyer, either by announcement made in open court or by personal service upon the defendant or her attorney, or by mail to the defendant or her attorney, and not in accordance with Texas Code of Criminal Procedure, Chapter 28, Article 28.01, Section 2. Defendant was made aware as defendant was working only because defendant's lawyer called her to notify her, since defendant had been in contact with the municipal court clerk for 4 years. In order to avoid this exact scenario, defendant called the court with the intention of speaking to the clerk. So because I was like, what's going on here? I've been calling the clerk for 4 years to avoid this. Let me call, right? Thinking that the clerk was going to answer. Defendant called the court with the intention of speaking to the clerk. The last time defendant had any communication with the clerk regarding the court dates of this case was in November 23, when by email defendant was reassured that no date would be set in the near future and that the court clerk would notify defendant, as she always does, of any future court dates. That email is Exhibit G. To defendant's surprise, Judge Felicita Gutierrez answered the phone, stating, "I'm going to put you on speaker. If it hangs up, call back." It hung up. Respondent didn't call to speak to the judge. However, the judge answered. When the defendant called back, as the judge requested, the judge answered again. Defendant asked judge why the case is being allowed on the docket when the district court case it stemmed from has yet to be given a date, and why are things suddenly changing from the way things had been done for 4 years. At this point, District Attorney Annette Hinojosa answers, as she had been in the same room as Judge Gutierrez, why was the prosecution and Judge Gutierrez in the same courtroom waiting for me and my lawyer to show up? Why were they in there like that? At this point, District Attorney Annette Hinojosa answers, as she had been in the same room as Judge Gutierrez and told defendant that she needed to speak to her lawyer, to which the defendant stated that this is a different kind of issue. I stated, "This is a different kind of issue. I will notify the 5th Administrative Region so that this can be avoided in the future. They need to know so that you all will not do this anymore." as is the pattern and practice of District Attorney Annette Hinojosa, to attempt to cause division, because what Annette Hinojosa has done this entire time was, with every lawyer, Annette Hinojosa and her team have tried to drive a wedge between my lawyers and me all the time. As is the pattern and practice of District Attorney Annette Hinojosa to attempt to cause division between the defendant and every attorney that has represented the defendant, she forwards the inquiry that the defendant, the email that I made to the 5th Administrative Region, she forwarded it to the lawyer and defendant via email, and implying that she just coincidentally happened to be in court because she knew that was wrong. So when she emailed this to my lawyer trying to tell on me, she stated that she just coincidentally happened to be in court when the defendant called. Why would the judge be answering the phone if court was in progress? The district attorney was trying to get out of anyone speculating that she was behaving in ex parte meeting with the judge in this case. The district attorney then implied to the defendant's lawyer that defendant was attempting to have an ex parte meeting. Then she had the nerve to say that I was trying to have an ex parte meeting with the judge and left out all the details that were just described above, attempting to put defendant's reputation in jeopardy with her own lawyer. She left out all the rest. She made it seem like I was calling to speak to the judge. Judge Felicita Gutierrez has made posts on her own Facebook disparaging defendant by disparaging the group that was opposing her re-election. On May 22nd, 2019, Judge Felicita Gutierrez made a post which included the following comments, quote, I was constantly targeted not only by my opponent but by 2 other candidates. I was candidate for mayor. Defendant was one of those candidates. Quote, I want you, the good, godly people of Raymondville, to know about this awful campaign so you can put a stop to the cancer growth trying to kill our town. Exhibit G. Risk of retaliation from Judge Felicita Gutierrez, number 22. If the judge of this court remains on this case, she will soon become aware that all of what is written here has been reduced to a grievance sent to the State Commission on Judicial Conduct, which will include an addendum to the grievance of the young females that will have testified in open court of the judge's comments in this case, should this motion be set for hearing. 23. Defendant has previously stated she would do all that democracy affords her to get a fair and ethical person in Judge Felicita Gutierrez's seat. Defendant has publicly stated multiple times that if she had to, she would run to win the seat held by the judge of this court herself. Number 24. The risk of the judge protecting the officers involved in this case by prioritizing the best interest of the officers involved in this case instead of the best interest and of the best interest of the district attorney, instead of conducting herself in a fair and impartial manner. If Judge Felicita Gutierrez stays on this case, defendant is at high risk of injustice due to a judge without a law degree deciding that important exculpatory evidence and impeachment evidence should not be admissible in an attempt to keep hidden the wrongdoings of the officers. Arguments and authorities. Number 25. The following are statements made with detail and particularly facts that are within the affiant's personal knowledge, except that facts may be stated on information and belief if the basis of that information is specifically stated. 2, would be admissible in evidence. And 3, if proven, would be sufficient to justify recusal or disqualification. 26. The right to a fair and impartial tribunal is guaranteed by both the Texas and United States Constitution. See Marshall versus Jericho, Incorporated 446 U.S. 238 242 1980, Reimer versus Lewis 206 Southwest 3D 732 736 Texas Appellate Dallas 2006, Metzger versus Seebeck 892 Southwest 2nd 20 3738, Texas Appellate Houston 1st District 1994, writ denied, This right is codified in Texas Rule of Civil Procedure 18B, which sets out the grounds for recusal. A judge must recuse herself when a valid motion is timely filed. See Texas Rules of Civil Procedure 18AB1, 18ABB. The grounds for disqualification are set out in Article 4, Section 11 of the Texas Constitution, disqualification of judges, and Article 30.01, the Texas Code of Criminal Procedure, which causes which disqualification. A. Judges' impartiality might reasonably be questioned. A judge must recuse herself if the judge's impartiality might reasonably be questioned. Texas Rules of Civil Procedure 18BB1, C in 51 Gambling Devices 298 Southwest 3D 768775, Texas Appellate Amarillo. 2009, petition denied. Woodruff versus Wright 51 Southwest 3D 723 73536, Texas Appellate, Texas Arcana. 2001, petition denied. The court must ask whether a reasonable member of the public, knowing all the facts in the public domain, would have a reasonable doubt that the judge is actually impartial. Regarding 51 Gambling 298 Southwest 3D at 75 Ex parte Ellis 275 Southwest 3D 109 115 to 16, Texas Appellate Austin 2008, no petition. Sears versus Olivares 28 Southwest 3D 611 613, Texas Appellate Corpus Christi 2000, no petition. C. Woodruff 51 Southwest at 7736, reasonable person standard. C. Impartiality might be questioned. O'Connor's Texas Civil Appeals, Chapter 3-1, Section 411, 2022. 27. By signing the warrant in number 13 above, Judge Felicita Gutierrez, any reasonable person would question the judge's impartiality, as no impartial judge would participate in violating the constitutional rights of a defendant. Number 28. A judge presiding over a case in which a party, the defendant, has challenged her elected seat by taking the seat herself cannot reasonably be expected to be impartial. Number 29. A judge presiding over a case in which a party, the defendant, has made a grievance alleging official misconduct and official oppression against her regulating agency cannot reasonably be expected to be impartial. Number 30. A judge presiding over a case in which a party, the defendant, was publicly called disparaging remarks such as cancer cannot reasonably be expected to be impartial. Number 31. A judge that is presiding over a case in which she has shown favoritism towards the state by allowing this case on the docket without notice to the defendant or her lawyer cannot reasonably be expected to be impartial. Number 32. A judge that is presiding over a case in which one of the parties, the defendant, whose demonstrations of free speech and democracy against officials have damaged her as personal attacks and goes on to make disparaging remarks, juvenile remarks to the point of bullying and name-calling, cannot reasonably be expected to be impartial. Number 33. A judge presiding over a case in which the judge has made comments about one of the parties in open court to others before her, such as the ones mentioned in number 18 above, cannot reasonably be expected to be impartial. Number 34. When a judge presiding over a case in which the judge has made comments about one of the parties in open court to others before her, such as the ones in number 18 above, demonstrates that she has personal knowledge of the case and that she has already decided defendant is guilty, this demonstrates a judge that cannot reasonably be expected to be impartial. B. Judge has a bias or prejudice. A judge must recuse herself if the judge has a personal bias or prejudice against respondents and the subject matter of cases pending against her. Texas R. Civil Procedure 18BB2, C. Wright versus Wright 867 Southwest 2D 807 811, Texas Appeal El Paso 1993, writ denied. CEG Aetna Life Insurance Company versus Lavoie 475 US 1813 823-26 1986. Judge was biased because successive judges own suit in lower court depending on ruling in case before judge. 35. By signing the warrant number 13 above, Judge Felicita Gutierrez demonstrated bias in favor of the state with this blatant disregard for the defendant's constitutional rights. An unbiased judge would never participate in the violation of a defendant's constitutional rights. 36. A judge presiding over a case in which a party, the defendant, has challenged her elected seat by taking the seat herself cannot possibly be expected to be without bias or prejudice. Number 37. A judge presiding over a case in which a party, the defendant, has made a grievance alleging official misconduct and official oppression against her to her regulating agency cannot reasonably be expected to be without bias or prejudice. Number 38. A judge presiding over a case in which a party, the defendant, was publicly called disparaging remarks such as cancer cannot reasonably be expected to be without prejudice or bias. Number 39. A judge that is presiding over a case in which she has shown favoritism towards the state by allowing this case on the docket without notice to the defendant or her lawyer cannot reasonably be without bias or prejudice. A judge that is presiding over a case in which one of the parties, the defendant, whose demonstrations of free speech and democracy against officials who have damaged her as personal attacks, and goes on to make disparaging remarks, juvenile remarks to the point of bullying and name-calling cannot reasonably be expected to be without bias or prejudice. A judge presiding over a case in which the judge has made comments about one of the parties in open court to others before her, such as the ones in number 18 above, cannot reasonably be without bias or prejudice. Number 42. A judge presiding over a case in which the judge has made comments about one of the parties in open court to others before her, such as the ones in number 18 above, demonstrates that she has personal knowledge of the case and that she has already decided defendant is guilty. This demonstrates a judge that cannot reasonably be expected to be without bias or prejudice. C. Judge has personal knowledge of a disputed fact. A judge must recuse herself if the judge has personal knowledge of a disputed evidentiary fact in the suit. Texas R. Civil Procedure 18BB3. 44. When a judge presiding over a case in which the judge has made comments about one of the parties in open court or others before her, such as the ones in number 18 above, demonstrates that she has personal knowledge of the case and she has already decided defendant is guilty. D. Article 5, Section 11, Texas Constitution, disqualification of judges. No judge shall sit in any case wherein the judge may be interested. Freedom Communications Incorporated versus Coronado, 372 Southwest 3D 621, Texas 2012, citations omitted. A judge is interested in a case and thus disqualified under Article 5, Section 11, if an order or judgment in this case will directly affect him to his personal or pecuniary loss or gain. 46. A reasonable person would conclude that the judge of this court is interested in this case, as this case has the potential to either make or break the careers of the law enforcement officers involved should the judge not allow exculpatory and impeachment evidence to be admitted. Number 47, the judge doing what judges took an oath to do, not doing what judges took an oath to do, and making sure justice is done, that all is fair, would expose District Attorney Annette Hinojosa for egregious violations of the Brady and the Michael Morton Act. Number 48, the judge doing what judges took an oath to do would show how the district attorney was not only aware since 2020 that exculpatory evidence and impeachment evidence existed and that those violations occurred, would demonstrate the district attorney's malicious prosecution and official oppression of the defendant, whereby demonstrating the district attorney's pattern and practice, a scheme of nearly a decade perpetuated by the district attorney to target the defendant. Number 49, the judge doing what judges do, it took an oath in this case to do, would show that when the district attorney was aware of the exculpatory evidence and impeachment evidence, instead of prosecuting those officers in their official capacity seen in the video, in the pending indictment, she knowingly, willfully, and with wanton disregard to justice not only maliciously prosecuted the defendant, she chose to instead leverage and weaponize said pending indictment catalyzed by a convicted felon lacking in all credibility with an active warrant at that time for violating felony probation, who made false allegations against defendant and using this to cause division between the defendant and her lawyers. That's when I tell you that a year ago, last October, she got so angry when I wouldn't take a plea bargain. And she said, if you don't do that, then I'm going to bring up the charges of the other DWI. And I said, go for it. Go for it. I'm fine. And also, we're going to get you for a witness tampering. which what she explained doesn't even fall under the guidelines of witness tampering, and the person who's the witness is a convicted felon. You're not supposed to allow those people to be witnesses because they're not credible. I wasn't gonna fall for that. The judge, if the judge doing what judges took an oath to do, would cause that district attorney should have catalyzed a prosecution on bad officers that will have the potential to go out and damage other citizens in other communities. Number 51, a judge presiding over this case that has demonstrated the above behaviors that would disqualify such a judge is a judge who a reasonable person would consider having great interest in this case, so that the best interest of justice is not of importance, and instead the judge would be interested in making sure officers she already implied did the right thing are protected, along with the district attorney who the judge has already shown favoritism towards. E, Article 3001, Texas Code of Criminal Procedure, causes which disqualify. Number 52, no judge or justice of the peace shall sit in any case where he may be the party injured. Number 53, a reasonable person would conclude that the judge of this court would feel injured if the defendant should be successful in this case for all the reasons stated in this section, arguments and authorities. Conclusion. Judge Gutierrez must recuse herself and be disqualified due to her partiality against the defendant, personal bias and prejudice against defendant, and her personal knowledge of the history of defendant and her conflict with other elected officials close and personal to the judge. Prayer. For these reasons, defendant asks the judge to recuse herself and be disqualified. The defendant requests that a judge with the law degree be mentioned in this motion, transfer this case to another court, or assign another judge not mentioned in this motion. In the alternative, defendant asks the judge to refer this motion to the Administrative Judicial District for a hearing on the motion. Respectfully submitted, Vanessa Tijerina, defendant. Yep. So there's all my rests. Except the last one, where I asked for all of the DWI information, and I have it. Where I'm the one that told the trooper, and I'm the one that found the hospital. I made the calls to get the fastest hospital to do my lab draw. But I was not sober, right? Okay. Yeah. Jury trial. Yes. All right. Thank you all so much. And there you go. There you go. I didn't want to have to do that. But the thing is, again, my name is Vanessa S. Tijerina. Vanessa S. Tijerina. Vanessa S, middle initial. Last name is T as in Tom, I-J-E-R-I, N as in Nancy, A. Vanessa S. Tijerina. If you are on one of the hate pages with the majority of white hateful people, if you ask them, who is she? They won't want to tell you. That's the reason that I put this thing all across my face. And somebody else, Ofelia Moreno's person KK, who is a white hater that I survived from, 3 years ago, has started using my videos and, taking some little stuff out. So I just did it like this to make her work harder. All right. Yeah, exactly. Sonia Magdaleno Vicario says, if you didn't know what you know, you would have been screwed a long time ago. Exactly. And these haters are saying, oh no, Same thing goes for you. You can blame yourself and those people, but yourself mostly for your choices. Okay? All right? Rest in peace, Chuck Mattingly. Okay? All right? Bernard Ammerman, you already know. You already know. But if you, Bernard, I meant what I said the other day. I would love to teach Annette Hinojosa a fucking lesson. Yeah. If no one else runs and it's just you and her, I will. You have all my support. Yeah. Because this woman needs to understand that she barely beat you. And she beat you only because of my negative campaign against you. That honestly, at this point, even though you started this whole mess, she has not, you never did anything as close as what she's done to me. Not even close. Okay? All right? So, who else? Judge Banales, not my fault. Not my fault. You saw the transcript where your friend Judge Cordova said that to me, and you still allowed him to preside over that case. You're to blame. They were your choices. Okay? All right. Judge Gutierrez, well, I had to do this. I had to do this. Everything there, were your choices, right? But, I had to do this and make this public. You can blame Ofelia Moreno for that. And her people, and KK, and the white hate groups, and Manny. Yeah. Annette Hinojosa, you're corrupt as fuck. I mean, look at everything you're doing to me. You are to blame for your own choices, and this would not have been read were it not for you can blame Ofelia Moreno, Manny with the mic, those 2 white hate pages. Okay? And obviously, again, yourself for your choices. Okay? Thank y'all so much. Again, the name is Vanessa S. Tijerina. Vanessa S. Tijerina. Vanessa S. Tijerina. The haters were saying, is this a survival page or a thirst trap page? I do what I want to do with this page. I let people know I am a testament to not giving up. I am a testament to things that we don't know what caused miracles, because what happened when I survived in that room and that mesquite log just broke like glass, no one can